I would now like to introduce our presenter, Kara Bashutski. Kara is a litigation lawyer with 12 years of experience litigating. She has practiced law both in Manitoba and in Saskatchewan, and she has appeared in small claims, the King's Bench, and the Court of Appeal in both provinces. Her practice focuses primarily on employment and labor law, where she currently practices at DFS Kaneski UnRuh LLP in Winnipeg. We are so pleased to have her here today, and without any further ado, I will pass it over to Kara. Thank you.
Thank you so much, Nina. Thanks everybody for joining today. My name is Kara Bashutski. I'm a litigation lawyer here in Winnipeg. And today we're going to talk about civil litigation. We're going to go through the basics of how and when to sue somebody in Manitoba. You should all be seeing my screen presentation online now. And Nina, if there's any issues, please just let me know. This is presented on behalf of the Community Legal Education Association for the 2024 Law Conference. What's really important to emphasize is that the information that I'm going to share with you today is just general legal information, and it's not specific legal advice. These situations can be very complex, and there's many turns and twists that may impact the information that I'm giving today. So if you need specific information, contact CLEA or talk to a lawyer. The information today is just meant as general legal advice related to Manitoba's civil litigation division at the Court of King's Bench. So with that said, our agenda today is going to be looking at when can someone sue. We're going to look at what is a cause of action. How do I know who to sue? We're going to look at what costs and likelihood of success look like and what to consider. We're going to look at the limitation periods. We're going to consider the appropriate forum for when you initiate litigation and basic procedures under the King's Bench Civil Division. If you have questions throughout the presentation, please just make a note of those and I'll address those at the end. So question one, when can someone sue? To be successful, you can sue a person or a business when your legal rights have been violated and you've suffered a loss and you have what's called a cause of action. We're going to look at what a cause of action is shortly. But really what this means is there's various types of disputes that you can bring forward in Manitoba in the Court of King's Bench. Again, we're looking at the Court of King's Bench Civil Division here. So this will not include things like criminal law. This does not include family law, and this does not include small claims matters. Things that might come up are property disputes, issues with your purchase and sale of your home, for example. It could include insurance disputes if you think you've been improperly denied insurance. It could include contractual dispute, which is a broad array of things like breach of your employment contract, or breach of a purchase and sale agreement, or breach of any service agreement by any service provider. This could also include things like wills and estates, although not in the civil division, and what's called torts. Torts can be a variety of things like negligence or misrepresentation that can span a wide variety of the law. Once you've decided to initiate litigation, before you're actually in court, you have to fill out, file, and serve what's called a statement of claim. A statement of claim is the document that initiates litigation, and you as the plaintiff have to complete and file and serve this document. If you go to Manitoba's government website and you see the Court of King's Bench rules, there'll be a list of court forms. Form 14A is the precedent document you can use for the statement of claim. We'll take a brief look at that here. This precedent document needs to be completed by you. We'll go through how to add the plaintiff and the defendant shortly. What's important is that the body of the claim has to be completed by you and should take some time and consideration to think about the proper cause of action that you have for your legal claim, and we'll look at that next. So before we go on to the next slide, I should just mention that once in a while, I do have some videos pre-recorded that will be inserted into the presentation today, just to give you an example of what it's like to actually walk through some of these things that I'm talking about. So when we initiate litigation, you have to start by that statement of claim that we just saw, and that's available online on the Court of King's Bench website. Now, to be successful, your statement of claim, which is the starting document for litigation, has to have an appropriate cause of action. So really a cause of action, it's just the basic or the legal basis for starting a lawsuit. So in other words, is there a claim that is sufficient to justify the attention or the assistance of the court? It has to be rooted in the law. This can be very complex, and it's best to see a lawyer or do some significant research before starting. A quote from the Supreme Court of Canada just re-emphasizes the importance of this, that a cause of action is every fact which would be necessary for you, the plaintiff, to prove in order to support his or her or their right to the judgment of the court. So a cause of action is the basis for your lawsuit, and it sets the foundation for the rest of the litigation. It really is best to see a lawyer in terms of framing the cause of action, because there's numerous causes of action that we have. Here's just some examples, but by no means is this a comprehensive list. You can have breaches of contract, like in employment law or purchase and sale of a house, for example. Breach of confidence could occur when somebody discloses confidential information. A breach of fiduciary duty often happens in employment law, where somebody who is effectively the business has maybe improperly competed with the company. There's the standard debt collection, like unpaid invoices. There's defamation, and there would be the Defamation Act of Manitoba. There's things like negligent misrepresentation that can occur in a variety of circumstances, like when you're purchasing goods or services, or in employment law when you are applying for a job and your employer maybe misstates some of the criteria of the job. There's intentional infliction of emotional distress, and there's intellectual property infringements. Again, this is just an example of some of the causes of action that are available and that you might be pursuing in the civil division. But what's really important is to properly research and look at the foundation for these causes of action. In the next slide, I'll go through some examples on how you can do this if you are doing this yourself as a self-rep. The reason that this is so important is because if you don't properly frame your cause of action in the initiating document, the statement of claim, your litigation could be struck out. The King's Bench rules, these are the rules that set, they're the rules that are for every litigant in Manitoba that govern the rules of court, allow for a defendant to strike out or to bring a motion to strike a pleading if it does not disclose a reasonable cause of action. I'll take you through where to access the King's Bench rules later, but here we see King's Bench Rule 2511D, which says a court can strike out a pleading if it does not disclose a reasonable cause of action. So you'll see it's very important, this initial step in litigation. One of the best resources for doing your own research on causes of action and case law in Canada is CanLEA. You can access this by going to canlea.org. CanLEA contains a database of case law and legislation across all of Canada. While it is an excellent resource, it won't contain all of the law or legislation, so you may need to do additional research. I'll walk you through a basic search so you can see an example of what you may need to do when you're trying to frame your cause of action for initiating litigation. Like any other search, the input that you put in is going to dictate the results. So you may need to play around with this. And this is just a basic example. Let's say that we have a claim in defamation, and we want to make sure that we're going to list the proper elements in the claim so that we have the right cause of action elements. We might start by saying, I want to know what's included in a statement claim in the same sentence as defamation. We would hit the search button and we see that 148 results are available. You can narrow this by cases, by legislation, or by commentary. In this case, let's look at the cases. And since we're in Manitoba, it's important that we focus on those cases. So I'm going to narrow the search to Manitoba law. You'll see many cases now that pop up, and it would be a good idea to make sure that you review most, if not all, of these cases. We're going to look at number 6 for an example. This is a 2020 decision by the Manitoba Court of King's Bench. And typically you would want to read this entire case, but for the purposes of this example, I'm just going to focus on paragraph 20. And here the court reviews the elements that are required to be pled in a statement of claim when you're alleging defamation. And we see here that they cite Brown on defamation, and it's important that we have the identity, the words that were published, the person or persons to whom they were published, and the date. With defamation, it goes on to say that you have to set out with particularity the alleged defamation and when, where, how, and by whom, and to whom it was made. So this is just an example of what you might need to do to properly frame your cause of action before initiating litigation. So as you can see, it can be quite complex to frame the proper cause of action, but it is very important. And if you look at CLEA's website, there's additional resources that go over how to do some research on canlea.org. In terms of the next question we want to look at, how do I know who to sue? Well, this may seem like an obvious question, but it actually can get quite complex. When we look at who to sue, we want to start just with some very basic definitions in terms of who are the parties to litigation. So let's go over that, looking at Form 14A, what's called the Statement of Claim. When you initiate litigation in the Court of King's Bench, you are what's called the plaintiff. On Form 14A, found on the King's Bench website, you would insert your name as the plaintiff. Here, for example, Jane Doe. The defendant is who the claim is against, and you would insert the name of the defendant or defendants on the claim here. So in terms of initiating litigation, you really want to focus on the person, the people, or the company that is directly responsible for your damages, for your loss, for that breach of law. When it comes to individuals, that's a lot easier to determine. Usually with an individual, you're going to have some type of pre-existing relationship. You'll know their first and their last name. And there's not much that you need to do there other than ensuring that you do name them properly. The main risks that can go wrong when you don't put in the proper names is that if you sue the wrong person or the wrong company, you might lose your case or be unable to recover any money. So again, this is a little simpler for individuals, but it can be more complex when you're looking at the company or the corporation that you're suing. So to avoid making this mistake, you want to ensure that you do some legal research and find the proper legal structure for the company. So I'm going to focus on the company because that's where it gets a little bit more complicated. For corporate defendants, there are various structures, various legal structures, and they all have an impact on how you would name them in the claim. So there could be partnerships, sole proprietorships, business names that are registered or unregistered, or incorporated organizations. So to find out what a company actually is, the only way to really do this is to do a search at the company's office. You can contact the company's office by email, or they're located on Broadway in Winnipeg. Or you can do a search online to find the right information for these corporations. So I'm going to walk you through an example. Going through the search online, it's called Companies Online. It's accessible by the website that you see here. You would have to create a personal profile. And for each search that you pull, it's going to be a $5 charge. I'm going to walk you through some of these pre-recorded screens that you would do as a step-by-step process to find your defendant. Just for the purposes of illustration, I've selected a company that's quite well known and just selected this at random, but to give you an example of how you would have to take a look at these company searches. In order to search for the proper defendant, you need to go to Companies Online on the government website. In order to search for the Once you've entered your information, you want to go search by name for information on entities, and then you can input the entity name that you'd like. There is more of an art than a science to this. So if we try searching for Walmart, we would enter the business name as we know it, and then we would see a list of all businesses that have that name. Now, note that how you search is going to impact the results that you get. So if we put a space in a dash with Walmart, we're now going to get different entities, as you see, than we had earlier. Similarly, if we say Walmart without any dash, and we look this up, we're once again going to find different businesses. So this does take some practice in terms of accessing the proper business. Let's say, however, that we think the proper business would be, just for by way of example, the Walmart Supercenter. We would highlight that and then go to View File Summary, which is a $5 charge. We would click yes. Once you have paid for the search, you can see the proper information needed in order to name the business. In this case, Walmart Supercenter, as an example, is a business name. We would then scroll down to see who it was registered by and do another search, as this was registered by Walmart Canada Corp. We see that Walmart Canada Corp here is a business corporation. In this case, it's actually extra provincially regulated, but we'll ignore that for the moment. Once you've found the proper names of your defendants, you would then enter it here into the name of the defendants on your form. So that was just a brief overview of what processes you have to do just to get to the point of naming your plaintiff, that's yourself, and the defendants. Those are more of the technical aspects of starting a statement of claim to initiate litigation. But before you even get to that point, you want to consider and spend some time evaluating whether or not it's worth it to sue. There's many costs involved, there's a lot of time involved, and you're not guaranteed any success. So let's take a look at this. You're going to have legal fees if you hire a lawyer to pursue your claim. However, even if you don't hire a lawyer, there's going to be other costs involved. If you're doing this yourself, you're still going to have out-of-pocket disbursements. So these are things like filing fees with the court. In order to file your statement of claim and start litigation, it costs $250 at the moment to file that statement of claim. You have to serve the documents, and if you're not doing that yourself, you're going to have to hire a process server. You may have to have experts to help prove the facts of your case, and you'll have to pay for their time and for their expert reports. There's also court reporters and transcript costs that may come involved in what's called discovery that we'll discuss later. So regardless, even if you're doing this yourself and without the assistance of a lawyer, you're going to have some significant costs that add up. If you are unsuccessful ultimately at trial, you may be ordered to be paying costs of the other party. Costs are always at the discretion of the court, so these can vary, but if you're not successful, typically you can anticipate paying costs of the other party to some extent. So there is a difficulty in terms of pursuing a claim where you're not ultimately successful, and you need to balance that. Another thing to consider in terms of costs, if you as the plaintiff initiate litigation, you may actually be faced with a counterclaim from the defendants. So the defendants may have a claim against you that they pursue. And now you're not just looking at costs of your claim, but also costs of their claim and the defense and time and stress that's involved in that. In terms of likelihood of success, you want to look at, is there a valid claim here? And the best thing to do is just take a really good look at not just your facts and what information that you have, but what is the other side saying? Again, they may have a good defense. They may actually say it was a third party that was involved and it's actually not them at all. They may say that you breached the agreement first, for example, in which case there could be a counterclaim against you. To get to this point, it's best to seek some legal advice, speak to a lawyer, or do some research yourself to get a sense of what other claims similar to yours are happening. A really important question is what does the defendant have in terms of money to pay? Just because you are ultimately successful doesn't mean that you're going to obtain judgment from the defendant. The defendant may be insolvent. The business may have gone under. There may be no money, even if you ultimately are successful, in which case you would have a judgment from court that is effectively a piece of paper and is not enforceable. So to help you assess whether or not you're going to be successful, whether or not it makes sense to proceed forward, I recommend that you start with a demand letter. It's just a letter that sets out what you are looking for, what amount of money you're seeking, the remedies, maybe the time frame, and the reasons that you're looking for that. You would then send that to the defendant. This is a really good strategy and highly recommended before starting litigation. The reason is litigation is costly and it's timely. Even if you're doing this without assistance of a lawyer, law and litigation can take years to go all the way through to trial. And there's a lot of stress, time commitment, and costs involved in that process. It also helps you understand the other party's position. And I think this is really important because if there may be a potential claim against you, or if the party actually has really good intentions to pay, but they just can't at the moment, this may help you understand where they're coming from. So it clarifies the expectations of all parties. It could preserve the relationship. Litigation certainly doesn't make people better friends. So if you do have a business or a personal relationship, this may be a better way to go about it first. And it could avoid negative publicity in terms of initiating litigation. Litigation is in the public realm. So when you file a statement of claim, the public does have access to that. And if your matter goes all the way through to trial, a trial becomes public record, and the decision of the judge will be publicized on websites like CLEA for everyone to read. Sometimes it could also be required by law, but even if it's not, it's a really good idea to send this demand letter. Limitation periods are very important when we're talking about litigation. And it becomes really important because if you initiate litigation and you're too late, your claim could fail just on that basis alone. So there are set time limitations for starting your claim. In Manitoba, the current act that you have to look at is the Limitations Act. This is a new act, and it has done away with the previous Limitation of Actions Act in Manitoba. Previous to this, this came into effect September 2022. Previous to this act, the Limitation of Actions Act had a, I'll call it basic limitation period of about 6 years. Now, the Limitation Act has changed this so that we have a basic limitation period 2 years from discovery. This does significantly change things, and it's still relatively new, so we're still figuring out what that means. You can go online to the government website listed here and take a look at the Limitations Act, as well as other legislation. What I do really want to stress is that you want to move very quickly and as quickly as possible, because if you miss your limitation period, even if you would have otherwise been successful, your claim will not succeed for that reason. Limitation periods are quite complex, and for this, I do encourage you to seek legal counsel. But I do just want to flag that we have this new Limitations Act since September of 2022, and the basic limitation period is 2 years. There's certainly other provisions in the Act that may apply to your situation, and there's an ongoing debate about what discovery means in a claim. But for example, in employment law, the date that you were terminated would be the date that you would like to use for figuring out when you have to sue your employer. It'd be 2 years from that date, for an example. One of the other basic questions that we want to go over is, what forum do you actually want to proceed with? So the presentation today is focusing all on Manitoba's Court of King's Bench in the Civil Division, but there are numerous other forums or jurisdictions that you could actually not only be better off served, but there are other places that you could only be served. So for example, let's take a look at the jurisdiction. And by this, I'm just referring to the province that we're in. We're currently located in Manitoba. Chances are the parties are going to also be located in Manitoba. And this makes it pretty easy that if the parties are located in Manitoba, the event occurred here, the documents were here, and the witnesses are all located here, you're going to want to sue in Manitoba. You typically initiate litigation in the jurisdiction closest to the parties. So if you're in Winnipeg, that would be here. If you're in Thompson, it might be there. However, this could change if you're dealing with parties that are outside of Canada or outside of Manitoba in different provinces. And it's not a simple process to look at this, but you just want to pay attention to the defendant. Are they living in Manitoba? Do they have assets in Manitoba that you could eventually collect upon? Is the business located here? Where are the witnesses? Where are the documents? If everything and everyone is located outside of Manitoba, if you started a claim here, you might have a challenge to the jurisdiction. You want to look at the events leading up to the dispute. So this is similar to what I was talking about before. If everything happened here in Manitoba, it's not going to be much of an issue. But if the parties were dealing with sale of goods in another province, well, you really want to look at where was the breach of contract, where were the parties located? And that may mean that Manitoba isn't the best place to initiate this litigation. If you're unsure, you should definitely speak to a lawyer, or you could always ensure that you file your statement of claim and see if there is a challenge to that jurisdiction by the defendants. Similarly, another thing that you may want to look at is, where was the contract itself executed? So these are all things that you may want to take a look at, and certainly not exhaustive, but some options that could impact the jurisdiction. Forum is another criteria that we want to look at. For certain issues in Manitoba, the court is not the proper place to start these. So for example, if you're dealing with a landlord and tenant dispute, you must go to the residential tenancies branch. However, if you're dealing with commercial, then you would actually want to go to the Court of King's Bench. If you are injured at work, then it would be the Workers' Compensation Board that would govern. So you would go through that administrative tribunal process. If you are a unionized employee and you have a workplace matter that has arisen, then you're going to want to follow the grievance and the arbitration process governed by your collective agreement. You're not going to court. If you are dealing with a small claims matter, then you're going to not be going to the Court of King's Bench because it's inappropriate, expensive, and time consuming, and you'd prefer to go to small claims court. There is another session and other videos already on small claims court in Manitoba, so I won't go over this. But what you should know is that currently Manitoba's limit for small claims is $15,000. And you can waive an excess amount. So if your claim is, for example, $18,000, you could waive that additional $3,000 and still go to small claims, and it may be beneficial for you. With small claims court, there's certain matters that you cannot take to that court. So for example, you cannot go to a small claims court for wrongful dismissals. You have to go to the Court of King's Bench. Or if you're unionized, you're going through the grievance or arbitration process. If you've suffered discrimination from a business, you would want to file a complaint with the Human Rights Commission in Manitoba or the Federal Commission if it's federally regulated. If you've lost out on some basic employment rights, let's say you haven't been paid vacation pay after you've resigned from employment, you'd best be better off to go to the Employment Standards Branch instead of through court for that. And finally, there could be specific contractual clauses that would bind you to things like arbitration. There are arbitration clauses in certain agreements or contracts that require you to go to arbitration instead of court. These are not always valid, so you would want to carefully review that, and you may want to seek some legal advice to determine if you really have given up a right to go to court instead of arbitration. So again, these are just some examples that you'd want to consider, and they're certainly not exhaustive, and each of these has many different considerations you want to look at, but just something to keep in mind. We're going to turn next to the basic procedures for the King's Bench Civil Division. I want to emphasize that these really are basic procedures because litigation can be very complex with many different strategies and many different outcomes or paths to that outcome, depending on what the case is and who the parties are. So for as many years as I've done this, I've never had a case go the same way, and I don't think I ever will. So I just want to emphasize this is quite basic. And from here, there are many different ways and many different things that could happen. Just starting out though, let's take a look at the court system in Manitoba. Now, this is just a snapshot of the courts. This doesn't contain all details of all the courts in Manitoba, but it helps us set the stage for the civil division. So in Manitoba, you can proceed by way of small claims. As I talked about earlier, this is for certain claims up to $15,000, but it wouldn't include certain things like wrongful dismissal. You can't go to small claims. You have the general division, and that's what I'm speaking about today. This includes civil, which I'm familiar with, and criminal trials, which I'm not speaking about. But it can also include small claims appeals and appeals from provincial court that isn't showing up on this list here as provincial court. And then finally, there's also the family division that deals with everything related to child custody and family matters. Again, we're not talking about that today. From each of these, you always have a right of appeal. And in Manitoba, we have the Court of Appeal. There's rules and regulations and laws concerning about how and when you can appeal. And from the Court of Appeal, your next right would be to the Supreme Court of Canada. But today we're focusing on the General Division, the Family Division, and the Family Division. and civil claims. So the foundation for claims in Manitoba is the Court of King's Bench rules. You can find these online at the address listed here. And you'll see a snapshot of some of the rules on the right-hand side. So for example, Court of King's Bench Rule 2501 says that an action commenced by statement of claim. This is what we were talking about earlier. In order to start an action in the court, you have to file a statement of claim, and that is Form 14A. These rules are complex, to say the least, very lengthy, and your best bet is to contact a lawyer to help you navigate these, but they are accessible online. So just walking through the basic procedures of a case in the court. Again, these are basic and it can vary from this, but you're going to start with filing and service of pleadings. That's your statement of claim that we talked about at the beginning. Then you're going to go through what's called discovery, which is an exchange of relevant information among the parties. And then you would attend a pretrial conference. This is a meeting with the other parties and the judge to schedule trial dates and to try and narrow the issues. And then if things don't settle, you're going to end up in trial. However, throughout the process and at any time, you should look at settlement or mediation. This is very important because when you leave things up to trial, you have a third party determining the outcome of your case. So we always encourage you to go through mediation or settlement. This can be done at any point in time, and it can be both formal and informal. So for example, there is a judicially assisted dispute resolution process. It's called a JADR. And this is a formal process through the court that you can do anytime as long as the other party consents. You would select a judge who would then help mediate your dispute among the other party to see if you can reach settlement. And I highly encourage you to consider mediation or settlement at any time throughout the process. As well, there could be motions and various types of motions at any point in time throughout litigation. I won't go into these in detail because it could really run the gamut, but they could be things like striking your statement of claim if it doesn't disclose a reasonable cause of action. And that can happen at any point in time throughout the process. So looking a little bit more in depth at filing and service of pleadings, you as the plaintiff have to start litigation by preparing that statement of claim that we saw, Form 14A, accessible on this website. You then have to pay the applicable fees at the court registry. That's currently $250 to file the claim. The court will then issue your claim with a stamped copy. You then take that stamped copy and you serve it personally on the defendants. Now, if we look at the purpose of the pleadings just a little bit more in detail, it is to define the issues for the parties in the court. So it's the roadmap and the foundation for the rest of litigation. The rules around pleadings in the Court of King's Bench rules are quite complex. Rule 25 lists some of the requirements. So not only do you have to have that cause of action, but you have to list a concise statement of the facts, the material facts. You don't want to list the evidence. So it's a fine distinction, but for example, the evidence might be things that come out at trial through your witnesses. The facts are just the basic underpinnings to support your cause of action. You want to list the damages that you are seeking, so the outcome, and make sure that each allegation in your claim is in a separate paragraph and number those paragraphs so it's easy to have the defendant respond to. And these are all set out in Rule 25. Once the court stamps and dates your statement of claim, you only have 6 months before you have to serve it on the defendant. So watch that time period. Once your claim has been served, which you can do yourself or you can hire a process server, once that claim has been served, you file an affidavit of service. This is available on the Court of King's Bench forms, Form 16B. So you file an affidavit of service for each defendant, and then you file that with the court. Now, once you have filed and served your statement of claim, the defendants have 20 days after service for them to file what's called a statement of defense. 20 days, this comes from the Court of King's Bench rules. However, I've put asterisks beside this and highlighted it because this rule is observed always in the breach, and it's very, very rare that you'll actually get a statement of defense within 20 days. It's considered professional courtesy to extend that time period when there's lawyers involved and even other self-reps to give themselves time to understand the case and file that defense. The defense will set out the reasons that they are not paying or the reasons that they think that they are not liable. And there may even be a counterclaim in response. There's other sessions this week that talk a little bit more in detail about these issues. Once you've received the statement of defense and you have completed the pleadings, then the parties engage in what's called discovery. So discovery really is just exchanging relevant information about the case with the other side. And there's two types of discovery that may be applicable in your case. And I say may because it depends again on the exact situation. But you have what's called an affidavit of documents. And this usually happens pretty quickly after you have received the statement of defense. Your duty as a plaintiff is to provide all relevant documents in a list to the other side. And once you do this, the defendant should be providing you with all their relevant documents. Once this is done, you typically have examinations for discovery. And this is further discovery that is done between the parties where you have a court reporter who records each party asking each other questions to discover the case. This is very important so that you understand what the other party's case is, and they can understand what your case is. Then you'll also go through what's called a pretrial conference. And the pretrial conference is where you and a judge and the other parties meet to discuss the potential settlement, whether you can narrow any of the issues, and how long you think the trial will last. At the pretrial conference is when you typically set the trial dates. In order to get a pretrial conference as a plaintiff, you file what's called a pretrial brief setting out the laws and the issue, and then you go seek your pretrial date with the court. And then finally, this all accumulates in a trial, assuming that things haven't settled up to this point. So at trial, very briefly, you will present your evidence by calling witnesses and entering your documents as exhibits. You need to tell your witnesses when to attend court, and if you don't think that they're going to be there voluntarily, you may have to issue a summons. You also present case law and legislation to support the reason why your legal rights have been breached. And then at the conclusion of trial, the judge may make their decision there, or more likely, they're going to reserve their decision. Finally, assuming that you are successful, that doesn't necessarily mean that you are going to collect on your judgment. So if you are successful at trial, you'll get a judgment in your favor. Unfortunately, that's not a guarantee that you're going to be paid. So if you're having trouble collecting after you're successful at trial, there are some steps that you can take. As always, I recommend trying to do this by agreement first. As you'll recall, we did the demand letter earlier, and it's always best to try and negotiate directly with the parties. If that doesn't work, there are various legal methods that you can use, like garnishment of wages, or you can go through seizure and sale of land or property. If you don't have any idea in terms of what the defendants have for assets, you may have to do some investigation. This could include contacting the sheriff's office. This could include searches for land registry to see if they own any land or property, or it could be credit bureaus to see if they owe any debts. And sometimes you have to do what's called an examination in aid of execution, which is where you ask the defendant questions on what type of assets and liabilities they have and their ability to pay your judgment. So again, I've gone through this quite quickly. And as you can see, there's a lot to each and every one of these. So just to recap, before we get to questions, you can sue when your legal rights have been breached, when you've suffered a loss, and when you have a cause of action. That cause of action is the legal basis for your claim, and I'd recommend you seek canley.org for some research before you file your claim. You have to sue those who are directly involved in your matter, and if you're dealing with companies, you want to do the proper searches at the company's office. Before initiating litigation, carefully assess the likelihood of success and send a demand letter before you initiate any litigation. You want to work quickly. Generally speaking, you have 2 years to sue after the claim has been discovered, but the quicker the better. And you want to consider where to sue. That includes where the parties are located, where the assets are located, and if the King's Bench really is the proper forum, or if it should be somewhere else like Residential Tenancies Branch or Employment Standards. Then, if you're ready to start litigation, you do so by filing and serving a statement of claim. You then exchange relevant documents, you attend a pretrial conference, and you go to trial. Thank you, everybody. I'm looking at the time, and I think we have just enough time to take a few questions if there are any.